It began on a Sunday morning. The kind of quiet morning that feels untouched by time. Soft lights spilling across trimmed lawns, sprinklers whispering, a calm rhythm over a neighborhood that believed itself perfect. Mark Ellison stood at his window, coffee steaming in his hand. Beyond the glass, his land stretched wide. A small acre of earth he had cleared, fenced, and nurtured over years. It was a sanctuary, a place where boundaries weren't just lines on paper, but memories, sweat, and pride. He'd built this property from the ground up, from the first shovel of dirt to the last coat of paint on the white fence. Every inch of it carried his fingerprint. Every nail reminded him of what it meant to own something earned. But perfection, he had learned, invites intrusion, and peace, in the wrong company, provokes envy. The Homeowners Association had tolerated Mark for years. He paid his dues, followed the rules, rarely attended meetings. To them, he was simply another homeowner, predictable, compliant, invisible, until the day he decided to build something different. It wasn't extravagant, just a small woodworking shed at the edge of his lot, a quiet place where he could craft furniture, work late, and listen to old records. Yet, in a world of strict regulations and fragile egos, that small shed became a spark. The complaints came first. Whispers about zoning, placement, aesthetics, an email from the boards suggesting the shed violated setback requirements. Mark reviewed the county maps himself. Everything was legal. He even had the surveyor's documents. Still, the HOA persisted. Letters escalated from polite suggestions to official warnings. By the third notice, their tone had changed. They weren't asking anymore. They were demanding. Mark answered once, calmly, citing state law, property rights, recorded plats. The letter was factual, respectful. He assumed that would be enough. But the board didn't want an answer. They wanted submission. 2 weeks later, Mark returned from a hardware store run to find tire tracks in the damp earth. The gate chain had been cut. His shed door hung open. And inside, footprints, fresh, muddy, careless. Someone had been inside his workshop. At first, he thought it was theft, but nothing was missing. Instead, small orange flags dotted his property. Survey markers, placed by the HOA's hired inspector. They had come onto his land without permission, taken measurements, photographed the interior, and left. The discovery left him frozen. Anger didn't come all at once. It seeped in slowly, deliberate, coiling like smoke in his chest. Trespass, that word repeated in his mind. It wasn't a mistake, not an oversight. It was arrogance. They believed their authority extended beyond the fence line. They believed that ownership could be overridden by intimidation. Mark sat that evening at his desk, the cut chain on the table before him. Outside, crickets murmured under the fading light. He looked at the chain, then at the deed framed on the wall. 2 pieces of metal and paper, proof that power only meant something when you enforced it. He began researching. State statutes, property codes, civil torts. Hours passed into the quiet hum of midnight. Legal definitions blurred until one stood out. Civil trespass, private property, damages per occurrence. The law was clear, and for the first time, so was his intention. They had stepped on his land. He would make them pay for every inch. That night marked a shift. Mark was no longer the quiet homeowner. He had become something else, a man with cause. And when a man with cause also has evidence, the story changes. Mark didn't rush. He moved with the kind of care that comes from knowing what's at stake. The cut chain sat on his kitchen table like an accusation. He photographed it, placed it in a plastic evidence bag, and labeled it with the date and time. Every small detail mattered. He started where all careful people start. With proof, he walked his property with a camera, taking wide shots of fence lines, close-ups of boot prints, and panoramic views showing the shed in relation to the neighbors' lots. Each image was time-stamped, each frame a line in a ledger that would not be easy to argue away. Neighbors watched from porches and windows. Some nodded when he passed, offering a muted sympathy. Others looked away, wary of becoming collateral in a fight that smelled of paperwork and power. Mark understood that quietly. That fear had a way of keeping people small. It's easier to pretend not to see than to get involved. He recorded everything. Video logs at dusk, audio notes after long meetings, a running journal of dates and actions. When the HOA posted another notice about unapproved structures, he saved it. When a board member sent a terse email, he forwarded it to a private folder. He built a chain of custody around the truth. Then he called a lawyer, not to vent, but to ask precise questions, statutory limits, remedies for trespass, what evidence would matter in court. The attorney's voice was calm, professional. She explained how civil trespass worked, how damages could be calculated, and crucially, how repeated, knowing trespass opened the door to punitive claims. She asked for everything he had collected. Mark sent it that night as a secure PDF. The law, she said, rewards people who keep receipts. That sentence lodged in his head like a compass. Armed with counsel, Mark upped the documentation. He rented a motion-activated camera to mount beside the shed, a device with infrared for night vision. He placed warning signs clearly visible along the fence line, private property, no trespassing, and filmed their installation. Any claim that the HOA had acted in ignorance would now be harder to sustain. On the third night, the camera caught movement. A pale rectangle of light crossed the frame. Boot prints reappeared. Gloved hands reached for the shed latch. A shadow moved under the eaves. Mark watched the footage alone at first, heart steady but mind racing. The grainy night vision images were enough. Trespassers had returned, and they had come with a purpose. He forwarded the clip to his attorney with a one-line note. You were right. The next morning, the HOA chair sent a letter to all residents, angry and defensive in tone, accusing unnamed troublemakers of spreading misinformation. It was a classic play. Loud words to drown out facts, but the camera didn't lie. The footage was clear in its implication that someone had entered private property. Mark filed a police report. He didn't expect a dramatic arrest. That's rarely how these things played out, but he did expect a record. The officer who took the report was patient and professional. He wrote down the chain of events, the cut chain, the video timestamp, and the names of board members who had been observed near the boundary. The report gave the next layer of official validation to Mark's story. The HOA board, cornered, pivoted into a different tactic. They issued an ultimatum. Stop making accusations, they wrote, or face formal action for defamation and harassment. The letter was performative and thin. Mark saved it in the same folder as the rest. Every attempt to intimidate him only tightened his resolve. In the weeks that followed, the neighborhood atmosphere thickened. Small things happened that read like intimidation tactics. A parked truck with a loud tailpipe idling in front of his home at night. A stack of anonymous flyers accusing him of stirring trouble. A social media thread started by a neighbor calling for community unity against outside agitators. It was all designed to isolate. It rarely worked on people prepared to document. Mark continued to collect witnesses. A landscaper who had seen board members crossing the fence. An elderly neighbor who remembered the day the chain had been cut and had watched a truck back into the lot. Witness statements were short and measured, given under the ordinary oath that neighbors rarely think to use. Still, they mattered. Human eyes were as valuable as camera lenses. As his file thickened, Mark's attorney wrote a demand letter. It outlined the evidence, cited the trespass law, and requested restitution for harm inflicted. It asked for an admission that the HOA had acted without authority. It demanded compensation for the cost of repairs to the gate and for the emotional distress Mark had suffered. The letter closed with a polite but firm threat. If the HOA did not respond, litigation would follow. The letter hit the board like a small shock. Members called emergency meetings, their tones clipped and defensive. They circulated talking points about overreach and procedural errors. Their public posture was composed. Privately, they scrambled. Someone forwarded the attorney's letter to the HOA's counsel. Lawyers began to converse in language that always feels both distant and immediate. Indemnity, indemnification, exposure. For Mark, the waiting was tense but purposeful. He had no desire for a prolonged vendetta. He wanted justice and clarity. The law could be a blunt instrument, and sometimes blunt instruments are necessary. He had asked for respect first. He had been ignored. Now he would demand it with facts. Then the escalation he hadn't expected arrived. The HOA filed a counterclaim. Not for trespass, but for nuisance. alleging that Mark's shed created visual disruption and decreased property values. Their counsel painted his documentation as harassment and suggested he'd staged events to implicate the board. It was a familiar tactic. If you can't win the facts, you attack the source. The board's counterclaim was audacious. It attempted to flip victim and aggressor. It tried to frame a man defending his property as the cause of community unrest. But Mark's file was comprehensive: bank receipts for the repair of the chain, video time-stamped and unedited, signed witness statements, and the police report formed a bulwark against the accusation. Public sentiment, however, is never purely rational. Neighbors who had supported Mark privately now hesitated under the threat of heated HOA meetings and social pressure. Some withdrew their statements. Fear, once again, proved a stubborn force. Mark felt a momentary isolation. He felt the old loneliness that at first made him retreat into his workshop. But he kept going. Documentation does not care for morale. It only needs rigor. He started preparing a robust damages claim. Not vindictive, not punitive beyond what the law allowed, but a careful accounting of costs: the chain replacement, the repair to the shed latch, the rental of the camera equipment, legal fees for consultations, and compensation for the emotional distress of having his sanctuary violated. The list was practical and modest. It would make a point without appearing frivolous. Meanwhile, the local paper smelled the story. A reporter asked questions in an even tone and wrote a piece that described the conflict as a troubling example of homeowner politics run amok. The article quoted legal experts who emphasized property rights and the importance of clear HOA governance. It was not a tabloid beat. It treated the subject seriously, and that shift to public gaze changed the dynamic once more. Now, the HOA had reputational risk. Their PR armor, thin as it was cracked. Board members began to speak more cautiously. Emails were drafted with legal oversight. The earlier swagger in their posture faded. Secrecy, their old safe cloak, frayed, and in that exposure, Mark found a quiet satisfaction. Not of revenge, but of restoration. Facts, when laid out faithfully, reshaped the narrative. The day the HOA's counsel replied to the demand letter, their response was less confident than their previous rhetoric. They offered cautiously to reimburse the chain replacement cost, a fraction of what Mark had documented, and to meet for mediation. It read like a small truce. But Mark and his attorney read it for what it was: a strategic opening. Mediation could settle costs, but it could not erase past trespass or public accountability. They proposed a settlement that required the HOA to publicly acknowledge the trespass and to adopt a policy clarifying that board members must request permission before entering private property. The mediation meeting took place in a neutral conference room. Fluorescent light, a polished table, and an atmosphere that felt like waiting for weather. Mark's attorney outlined the evidence succinctly. The HOA's counsel spoke in softer tones than before. The mediator suggested compromise. Tensions eased into negotiation. And after a long afternoon, the HOA agreed to the written admission and the policy change. They agreed to pay for repairs and to reimburse certain documented costs. It was not the courtroom vindication Mark had once envisioned. It was something quieter and arguably more powerful. Public acknowledgement, new rules, and a correction written into the HOA's procedures. The direct act of trespass would be recorded and renounced, and the board's authority would be curtailed with procedural safeguards. Yet even in victory, Mark remained watchful. Admissions and new policies are only as good as their enforcement. He requested that the new rules be voted into the recorded minutes and distributed to every homeowner. He asked that the mediator's report be filed with the HOA's registry and the county clerk. Transparency, he had learned, was a living thing. It needed tending. The board complied, reluctantly, and the community received the official documents in the mail. For many, the papers were a distant bureaucratic detail. For Mark, they were a shield. They were proof that trespass had consequences, that ownership meant rights enforceable by law, and that, sometimes, the only language bullies understand is the one written in statute and record. In the weeks after mediation, the neighborhood drifted toward normalcy. The quiet did not return untouched. There were lingering looks and polite nods. but also an underlying sense that boundaries had been repaired. Mark continued to keep his logs updated, his cameras in place for a time, not out of paranoia but prudence. Vigilance, he discovered, is a practice, not a state. As summer warmed the air, children played again near the fence, their laughter blurring the memory of the trespass like sunlight through leaves. Mark mended his chain one last time and stored it in a small wooden box. The box had a label, "Returned, Record of Trespass, 2025. It was both a relic and a reminder. He had wanted restoration, not spectacle. The law had given him a mechanism. The community had finally given him respect. The board had agreed, on record, to a change in behavior. And in the quiet aftermath, the balance that had been upset slowly returned. But Mark also knew the story traveled beyond his street. Others were watching. Neighbors in nearby subdivisions who read the local paper and wondered what they would do when the HOA crossed a line of their own. He had sent them a message. Not loud, not theatrical, but clear. Trespass on private property carries a cost. Accountability is possible when people choose to document. And sometimes holding on to ordinary dignity means being willing to do extraordinary paperwork. The camera in his yard recorded a passing evening storm one day, and, in its glow, Mark saw the reflection of the shed and the fence. He thought of the chain, the boot prints, the quiet nights of research. He thought of the mediation, the admission, and the policy change, and he felt a slow, steady satisfaction, not of hostility, but of boundaries restored and rights remembered. Mark thought the story had reached its conclusion. The mediation had gone well. The admission letter was signed. The reimbursement had cleared, yet the quiet that followed felt unfinished. There was still something unresolved beneath the calm surface, something about justice that doesn't feel whole until it balances completely. He kept noticing the small ways the HOA tried to rewrite history. A newsletter article framed the incident as a miscommunication resolved through community cooperation. There was no mention of trespass, no word about the policy change being forced by legal action. They wanted to shape the narrative as if it had been a friendly misunderstanding. It was not. It had been intrusion, intimidation, and cover-up. Mark's attorney reminded him that reputation management is often the last defense of those who lose control. That paper smiles can erase signed admissions. Still, the attempt irritated him. He had worked methodically for months, endured nights of stress and silence, all to preserve the sanctity of boundaries. And now, the same people who crossed his fence wanted to polish their image on his patience. That was when he made a decision, not of anger, but of clarity. He would hold them accountable not only morally, but financially. The settlement had covered direct costs. It hadn't touched consequential damages. The hours spent securing evidence, the anxiety, the diminished sense of safety. These weren't abstract grievances. They were measurable harm. And under the law, harm carried weight. He reviewed the ledger he'd kept. Each entry was careful, dated, substantiated. Invoices for equipment, time logs for missed workdays, notes from therapy sessions that helped him process the invasion of privacy. It was meticulous, unemotional data, the kind of documentation that converts experience in a lawful argument. His attorney approved. They would submit a supplementary claim for additional damages. The new filing was short but potent. It requested reimbursement for the documented indirect losses, attorney's fees, and an additional penalty for willful trespass. The figure wasn't astronomical. It was reasonable, calculated to make a point without appearing vengeful. But it startled the HOA's counsel, because it was unassailable. Every number had evidence behind it. Every sentence referred back to statute. The board reacted with disbelief. Their private correspondence, later obtained through discovery, revealed panic. Some members feared a lawsuit would open old wounds. Others insisted they could stonewall. The president, who had personally approved the earlier trespass, insisted it was time to stand firm. The phrase would later appear in a deposition. The irony, in hindsight, was perfect. As the process moved forward, Mark found himself surrounded by a different kind of silence. The waiting kind. Legal time is slow. Days stretch. Documents circulate. Every response is measured in weeks. Yet beneath that stillness, there is power. Because once a claim enters the system, It exists independently. You can't intimidate paper. You can't gaslight a court docket. Word of the filing spread quietly through the community. Neighbors whispered in driveways and at mailboxes. Some offered congratulations in hushed tones. Others avoided eye contact, uncomfortable with how close accountability felt. People like comfort, and justice, when it arrives, often disturbs that comfort. Meanwhile, Mark returned to his routines. He tended his small vegetable patch, fixed loose boards, and continued his morning walks. These were acts of reclamation, small rituals that said, "This land is mine again." Each seed planted, each tool returned to its hook, was a gesture of ownership reaffirmed. Months later, the HOA folded. Their counsel reached out with a proposal, an out-of-court settlement to cover the supplemental claim. The terms were simple: full reimbursement, payment of attorney's fees, and a formal letter of apology from the board president. The irony was that the apology cost more in pride than the check cost in dollars. Mark accepted, not for the money, though it helped, but for the precedent. The apology arrived on crisp stationery, signed by the same hand that had once ordered him to stop spreading misinformation. It acknowledged unauthorized entry, confirmed policy changes, and expressed regret. Reading it, Mark felt no triumph, only closure. Sometimes justice is quiet. Sometimes it's a letter folded neatly in a file. The story didn't end there. Local media picked up the case again, this time with the headline, "Homeowner wins legal battle against HOA trespass." It became a talking point in online forums and neighborhood associations. Attorneys cited it in workshops about homeowner rights. It rippled outward, a small but meaningful precedent, a reminder that homeowners aren't powerless. For Mark, the aftermath was reflective. He had learned that legality isn't just about statutes. It's about persistence, documentation, and dignity. The trespass had started as a physical act, but it became symbolic, a test of how far one man would go to preserve the principle that home means sovereignty. He took down a motion camera one afternoon, its lens dusty from months of watching. The yard was still, the fence repaired, the air smelled of cedar and soil. The sound of children riding bikes on the street carried easily over the hedge, and for the first time in many months, he felt simple peace. When the final check cleared and the last document was filed, Mark archived everything in a black binder labeled "Case Closed." He stored it in his office cabinet, beneath old tax files and manuals. It was a record not just of trespass, but of transformation, of what happens when patience meets principle. Weeks later, his attorney called to congratulate him. The case had prompted the county to review HOA procedural guidelines. New policies were being recommended, stricter boundaries on property access, clearer requirements for homeowner consent. His private struggle had turned into public policy, and that, more than any check, was victory. In the quiet of an evening rain, Mark stood at his window, watching water bead along the fence rails. He thought of the first night he found the cut chain, how disbelief had turned to anger, and anger into resolve. He thought of the folder of evidence, the courtroom filings, the apology letter. He thought of how justice doesn't always roar. Sometimes it whispers, line by line, through the steady patience of one man unwilling to yield. And as the storm eased, he smiled faintly. The house lights reflected in the wet grass. The fence, once a boundary of conflict, now looked like a monument, not of defiance, but of dignity. In the end, the HOA had trespassed on his land, but he had reclaimed something greater. His peace, his confidence, his proof that fairness, though slow, is inevitable when met with truth. And as he turned away from the window, the binder on his shelf gleamed faintly under the lamp's glow. The story was over. The lesson remained. In the months that followed, the rhythm of the neighborhood changed. There were fewer anonymous notices, fewer whispered threats wrapped in bureaucratic language. Boundaries had been redefined, not on paper, but in memory. The story of Mark's case had become a cautionary tale that traveled faster than any rulebook. At first, the HOA tried to pretend nothing had happened. Meetings opened with talk about landscaping and budgets. The president avoided the subject, his sentences careful and bland, but silence doesn't erase a record. Every homeowner knew the outcome, and each knew that a man with patience and documentation could face a board and win. That knowledge was power, quiet and contagious. Mark's life returned to something resembling normal. Mornings were again about coffee and the soft hiss of sprinklers. The shed that started everything became his refuge, its walls lined with tools and half-finished projects. Sometimes he would pause mid-work, glance at the repaired gate, and feel the faint weight of history there. A reminder that peace isn't free, it's defended. He noticed small shifts in how neighbors acted. People waved more, spoke longer at mailboxes. Fences that once divided now defined respect. Children played without parents glancing nervously at the street. The community had learned that rules could protect, but they could also overreach. The difference lay in humility. One evening, the new HOA board, freshly elected and cautious, visited him. They asked for guidance on revising community policy. It was a strange reversal. The homeowner, once targeted, now advising the system that tried to silence him. Mark agreed, not out of pride, but out of principle. He believed that accountability should lead to improvement, not revenge. They sat around his kitchen table under the low hum of a single light. He explained how transparency prevents resentment, how courtesy costs less than confrontation. They listened, took notes, nodded. When they left, he felt a quiet satisfaction. Not triumph, but repair. Local media followed up months later, calling the case a blueprint for boundary integrity. Law blog cited it. Seminars used it as an example of civil remedy without escalation. It became a small ripple in a larger movement that reminded communities that power must remain grounded in consent. Yet beyond the headlines and policy, what stayed with Mark were the nights of doubt. The fear that maybe fighting back would isolate him. The exhaustion of reading legal codes at 2 a.m. The moments when principle felt heavier than peace. Those memories anchored him. They kept his victory human. On the first anniversary of the settlement, he walked the perimeter of his property at dusk. The air smelled of cut grass and cedar. He traced his fingers along the fence post where the chain had once hung broken. Now it was whole, sealed, strong. Beyond it, fireflies flickered like quiet witnesses. He thought about what justice had cost him. Not in money, but in energy, in solitude, in patience. He thought about how every boundary, physical or moral, is only as strong as one's willingness to defend it. And he felt gratitude that he had defended his. Inside, the binder still rested on the shelf. He hadn't opened it in months. It didn't need to be opened. Its presence was enough, proof that dignity, when documented, becomes legacy. In the weeks that followed, he began mentoring neighbors facing smaller disputes. Fence height, noise ordinances, parking. He never told them what to do. He simply shared a sentence. Know the law, keep your records, stand calmly. And that was enough. By autumn, the neighborhood looked the same but felt different. The lawns were trimmed, the meetings civil. There was laughter again at community gatherings. Conflict hadn't vanished, but fear had, and in its place stood something steadier, respect. On the final night of summer, Mark sat on his porch, the air warm and full of crickets. The porch light cast a soft glow across the driveway where his truck rested, dusted with pollen and peace. He sipped his coffee, stared in the quiet, and thought of how small victories can echo louder than any headline. Justice, he realized, doesn't always arrive in courts or checks. Sometimes it arrives in silence, in the knowledge that those who wronged you now understand why they shouldn't again. That understanding is its own sentence. The camera of memory pulls back slowly, the house bathed in soft amber light, the repaired fence glinting faintly under the moon. The man at ease in his own yard. No triumphal music, just the hum of a neighborhood that finally learned where its borders truly lie. And in that calm, the story closes, not with revenge, but with equilibrium. They trespassed, and he answered not with rage, but with law. They took ground, and he reclaimed principle. And when the dust settled, it was not noise that remained, but the steady heartbeat of justice fulfilled. Fade to black. Soft title text over the screen. HOA USA Stories, True Boundaries. True Justice.